This morning we're going to have a discussion about experts. We've done something along these lines once before in the last sort of 15 months or so. But we're going to have another look because there's various bits of news that have come up recently that are quite interesting that hopefully we'll have a discussion about this morning. We've got three great panellists. So first of all, we've got one of Her Majesty's Counsel, Jessica Stevens, QC. She was called to the bar in 2001 and took silk in 2011. She now represents a range of clients from employers to architects on matters of construction law. She's been described as, and I always like these quotes that we get from the chambers and the various directories, a sharp wit with an excellent manner for cross-examination, a very quick thinker who addresses the court fluently and cogently, and impresses commentators with her incisive mind and straightforward, nuanced arguments. So we'll be looking forward to some of those this morning. Next up, we've got Matt Lindsay, who's a delay expert with a relatively new firm that you may or may not have come across before, Chronos Consult. Matt is a chartered builder and planner with over 15 years of experience. He's been appointed as an expert and is fellow of the Chartered Institute of Arbitrators and the CIOB. Matt, along with his business partner Tim Marlowe, founded Chronos. They now have a team of around 10 delay experts working purely on matters of planning and time, so they're quite niche. But it's certainly an area of construction disputes that comes up frequently enough for us to have a good conversation this morning. And finally, Dan Miles, who is a chartered quantity surveyor with Aquila Forensics. Dan is another expert witness with testifying experience and also with around 15 years experience in the industry. Dan initially started work in civil engineering and worked on various projects before entering consultancy. And he's also a lecturer at both Stuttgart and Derby universities on the subject of contract administration. So three great speakers, and hopefully we had a little conversation before this about the merits of different forms of paper and filing, so hopefully we'll try and avoid too much discussion of that nature. But let's start with Jessica and perhaps have a look at experts and how we've sent out an email in the run-up to this saying, how do you like your experts? And we'd perhaps ask Jessica how she likes her experts. So hot-tubbing or cross-examination?
I mean, I ideally, present company accepted, not in a hot tub. I think, you know, as a barrister, we're trained to cross-examine. That's how we try and get our argument and our point across. And I find it quite frustrating to effectively put somebody up and let somebody else have a go. And it's not even really having a go, it's sort of exploring their views. And to my mind, once you've got to a trial situation, there's probably more between the parties than a very straightforward technical dispute that can be resolved by the judge. So to my mind, I prefer cross-examination. I've got control over it. I know what I want to ask. I've done my research. I know, or at least I hope I know where there might be sensitivity with the expert over certain points. And I'm not dependent upon a judge having done sufficient pre-reading or immediately having a sort of grasp on what are key facts, or even not necessarily key facts, but the points I'd like to make. So to some extent with hot-tubbing, you are a little in the lap of the gods, the god being the judge or the tribunal. And I'm just much happier taking responsibility and running it myself.
That's interesting, because yeah, I think I was on another webinar, as I want to do, and the QC was on that one, had a similar view. I don't know if Matt or Dan, do you have any experience or views on either of those formats for finding out what's going on?
I think it's one of these ones that hot-tubbing, from the expert's point of view, can be kind of a good thing and a blessing and a curse. There's the advantage that it's quite nice sometimes when you're next to an opposing expert or your fellow expert, sorry, to have the ability to turn around and say, well, actually, I disagree with that point for the following reasons. But there's a danger, and you need to be very careful, I think, as an expert, not to drift into a role of advocacy when you're in the hot tub, and to maintain the fact that you're not expressing a point of position, you're expressing an opinion, and it's not drifting too far outside of your remit. But there is the benefit that it's quite nice to have the two views aligned next to each other, and have those opinions kind of explored. although also, of course, the worst bit for the expert is surviving the grilling from the QC. So it's nice to avoid that a little bit.
Good. Okay, so if we can move on to impartiality and conflicts, and I think this is something that comes up a lot and has come up a lot in recent months. Where is the line, I guess, is the question. I attended a webinar a week or so ago where the speaker said it's important you ensure that your expert holds views that are good for your client. Have you got any thoughts on that? Perhaps, Matt, if we start with you.
Yeah, I think it's an interesting viewpoint it's put forward, but I'm not sure I completely agree. So as an instructor expert, our responsibility is to the court to arbitrate, adjudicate, and it should be our opinion based on the facts that are presented, even if they're good, bad, or indifferent for the client. I think if the client considers they've got a positive case going forward, then and they're going to litigation, they may have had some sort of expert advice to give them set their position. I mean, the danger with some early advice is that it might change if the experts continue through. It might change later on when more evidence comes forward and facts come through. But we've got to try to remain neutral in that position and not try to be swayed by the client or the legal representatives, and not just stick with an earlier opinion. I mean, it's always a difficulty balancing the reliance placed on the information and the opinions of the client's team. As I find when trying to discover the real issues, so if we're in an adjudication, you've got to rely on building a relationship with the site team or the client team to try to understand the sort of technical issues and understanding the project, how it was run. And that's the quickest way I find that is to actually sort of speak with the site team, work with them. But on the flip side, and it goes without saying that generally their views are skewed towards their own interests. And this is where we need to sort of investigate and interrogate the information further. I mean, there's plenty of case law in this area. Obviously, if an expert's found wanting, if he just accepts the opinions and the views of his client, then ultimately there's a hint of bias, and the judge can obviously just ignore his opinion. And obviously there's a perception it's a waste of time of the expert, and obviously it's a damage to their reputation. I mean, I spoke with the team on this issue as well, and obviously the threshold that impartiality is tested may vary through the different processes as well. So for example, in adjudication, you may only get three days if you're as part of the responding party. And obviously you need more reliance on the client and their team to get you up to speed on it. Obviously you still can be impartial, but the short process and the minimal time to get up to speed can be difficult to get up to speed with the dispute. But on the other hand, in litigation, you have the advantage of document disclosure, exchanges of reports and expert meetings. So this obviously provides you with time to reconsider the information and narrow down the areas of dispute. So I think from a point of view, the line isn't clear cut, but as long as you sort of err to the side of caution and make sure you consider the facts and the other arguments and not just go with what the client's viewpoint is, then you can demonstrate that there's no sort of bias in there.
Dan, have you got any thoughts on that, where the line might be drawn, or any thoughts on impartiality?
I think the only thing to add to that is it probably varies slightly depending on who you're asking that question of. Now, of course, the answer given by Matt very much agrees from a point of view of the expert and the need to be impartial, but you tend to find that as an expert, you become known for holding particular approaches to analysis or particular points of view. And therefore, if the question is being asked of the legal team are probably more likely to select an expert at the start who they know from experience or from written papers and the other things that we put out into the world, that the views that you're more likely to, or the approach you're likely to take to the cases will be more favourable to their client than another expert. So I don't think it necessarily I don't think that statement necessarily has to be instantly counter to your duty of impartiality. It might mean that actually when you're selecting your expert, your legal team are more likely to select the expert that they know preemptively are going to be more favourable to their to their case. And that's just the fact that it comes back to that overall test of impartiality, which is if you're appointed by the other side, would you give the same figure and the same opinion and the same report? And the answer is yes, as it should be for an expert. Then again, that goes to the fact that experts should be consistently holding the same opinion, which may well have an impact as to which party appoints them in future cases.
Good stuff. Okay, thank you. So the next thing about on the similar sort of subject, and this was something that came up for those who read it, Gordon Exell's brilliant blog of various cases, the civil litigation blog that he writes, and it was a thing about conflicts and relationships and the various sorts of things, and things that we kind of live off. Certainly, I kind of live off is corporate hospitality and events and socializing and all of those lovely things that we like to do as business development type people. And the example he used was one of Wimbledon, but I'm going to do one of, because I know Jessica likes or has a dog or two, and so if Jessica, a fan of all things canine, takes you, Matt or Dan, to Crufts, and then a year later you're brought in to work with Jessica as an expert on a dispute that she's working on, would you expect to disclose that trip that you'd had where she'd taken you to Crufts, or yes, she'd taken you to Crufts, to the tribunal? Is that something, Dan and Matt, would you have a view on whether you would consider that a relationship that should be disclosed?
I'll let you go with that one, Dan.
Thanks, Dan. I think the truth is that so much of our business development and so much of our marketing is based off corporate hospitality and building their relationships with the legal firms and with counsel. And it's one of these ones that, particularly in the larger cases, you spend a lot of time working very closely with the legal teams through some fairly stressful times, particularly in the run up to hearings and giving evidence. So the relationship you have with the legal teams is very important. In the past, I think if you'd done a one-off trip to Crufts, that wouldn't have been something which I would have disclosed. Reading the blog and the case that he refers to, it has prompted us to reconsider that internally, and it might be something where you need to include in our declaration a new sentence that says we have engaged with the instructing solicitors for purposes of marketing. This does not impact or create any biased or kind of conflicts within my opinion. So it's something which I think, having read the case law that's quoted, we may need to address and consider. Previously, that's not something which we would have included within the declaration.
Yeah,
I think that's controversial too much, but
yeah, I thought it was interesting. I have to say, I don't think my old firm, where most people know where I used to work, we would have, or experts there would necessarily have declared a corporate hospitality event that happened a year before, because, as you say, it's something that happened as routine, but it is something that raises an interesting point. And Matt, have you guys got any thoughts on that, or indeed Jess, if you've got any thoughts?
Yeah, I think I sort of go. Sorry, Jess. I sort of along the lines of Dan's opinion there. That it depends on the sort of depth of the relationship and the amount that you do with the solicitor. I mean, one visit to Crufts, maybe, I don't know if it quite justifies going in the report, but yeah, if you're building a relationship and there's more behind it, then yeah, I think it's probably worthwhile to put some kind of statement within your reports.
And certainly from counsel's perspective, what would you say, Jessica?
I mean, I was slightly surprised by this, actually, but I think the whole sort of the tension between how much disclosure you give of potential conflicts, it sort of ebbs and flows with cases over the course of time. And I think we're currently in a period where, for whatever reason, there's real concern about experts being truly independent. So I think at the moment there will be more of an inclination towards disclosing almost any link, no matter how minor. I suspect there will come a point when judges will say, I mean, particularly given, the quantum and the delay experts, do you know what, I really don't need 20 pages of your 25-page report setting out what you've done with the various parties involved. And I suspect if there's full disclosure provided, then there would be a fairly even coverage of probably both parties to the dispute, because again and again it's the same reasonably well-known experts that they're in your room or your chambers one week, and for a fact they're in the other side on a different matter the next week. You know, it's a small world, and I think, you know, that realistically, although at the moment there might be more of a push to disclose links and the like, realistically it's a small world and everybody is relatively capable of acting independently.
Yeah, Annie has very helpfully posted the link into the chat for Gordon Exel's blog, which is quite interesting, and there is quite often some pieces of relevance to experts, as well as pieces about construction law and various other things, amongst all the other things.
Back to that, I mean, one point I would make, I cross-examined an expert once in Bank of Ireland and Watts, and it's still the most fun I've ever had with an expert. But I mean, what was interesting there was, in the sort of part of the CV, there was lots of boasting about how much work they'd done and what their experience was the fact it all seemed to be for the same client. And that, I think, is when disclosure of interest is potentially, you know, a problem. It's the repetition, and it's the fact that it excludes, you know, other parties, other participants. It's far too close and exclusive.
Yeah, that's a good point. Thank you very much, Jess. So next question, and it's another kind of quick fire one for you, Jess, is single joint or party appointed? Any preference, and why?
Party appointed is my preference. I understand entirely the rationale for having, you know, a single joint expert. It's the court's hope that there could be this, you know, terribly grand single joint expert who can sweep in, give his views, and the parties go, that's the answer, we'll settle. But in my experience, it isn't really that simple. There's normally an enormous fight about the scope of the instructions. There's then your client saying, but what about when you receive the report? There's then, I think, the need to frame questions to the expert to make sure you've got, you know, the best out of this process as you can get. And unless it's relatively straightforward or not a key part of the dispute, I think you inevitably end up with your own expert in the background helping you formulate the questions and advise where they think the real answer is and where the single joint expert might have gone wrong. So my experience of the process, notwithstanding its sort of quite laudable intentions, my experience is it's inevitably more costly and expensive, and I don't think I've ever been involved in a case with a single joint expert, particularly one in relation to a vital key point that the case turns on, where there hasn't inevitably been 3 experts rather than the 2 you would ordinarily have, and at some point an application for further evidence.
Dan and Matt, any extra views? Have you been involved in single joint expert appointments, or have you got any experience of either, or views on which is better, which works best?
I think so. Agreeing with Jessica, there is the benefit on the slightly simpler, smaller cases where the appointment can work effectively and work well. But on anything of any value or complexity, there is a danger that each party then appoints their own additional experts. It actually increases rather than decreases the costs for the parties, and you're left in the middle with a bit of a punch bag dealing with questions from everybody. And it's not always, I think there is, as the system is currently constructed within the UK, within England and Wales, that there is definite benefit to, on the larger cases, to having party appointed experts rather than single joint experts.
And my opinion sort of echoes that of Dan, that even if you get a single joint expert, then the other parties are likely to bring in their own experts to review it anyway. So like I said, the cost will then go naturally in that case.
I do find this interesting because I went to, there was an SCL conference years ago in Paris, where there was a debate over the kind of the civil code system, where there is a court appointed expert, whether you like it or not. And the people in the room who were from France were horrified by our concept of a party appointed expert. And I said, well, how can they possibly be impartial? And it was an interesting debate. There was a whole discussion around how it could possibly work, but it does, as you say, it does seem to work quite well. Dan, appointments. how aware should you find your expert? Should experts be selected for their track record, their views, their experience, or a bit of everything? What's your view on how to find a good expert?
So working backwards from that on that question, I think it's very much a question of a little bit of everything, because if you take one of those things out of the equation, it's going to fall flat, and therefore it might be a question not of should it be one of these things, it's what's the proportions. If you don't have the experience in the item that you're opining upon, you shouldn't be opining upon it, and you'll probably fall foul fairly quickly in cross-examination. If you're in a situation where we spoke earlier on that you are known to hold particular opinions on approach analysis that are now counter to the case, is unlikely you're going to get appointed to begin with. And generally, there's always the inevitable question of your track record. Have you actually had experience of acting on these kind of matters? And has your views or has your opinion been found favourably by tribunals? So as to which one takes priority, well, it has to start with the fact that you have to have relevant experience. As to the other items, that's probably more of a question for your legal teams, and it probably comes back to the nature of the matter in hand and the value of the value, well, in my case, quantum, the actual about the quantum of the dispute. So it's a mixture that's going to be dependent upon the case in hand, which is not a particularly helpful answer, but it has to start with you need to have the experience about to actually effectively and appropriately opine on the matter.
I suppose with practical experience, and maybe this is one for Jeff as well, because I see quite a few delay experts CVs that they've covered every industry, or they've been involved in disputes and matters from all different industries, but practical experience on them they have none. Obviously, we're program experts, but I suppose from an appointing a lawyer's view, would you go with somebody with more practical experience on that type of job, who've actually experienced that type of job, or would you pick someone that's probably been more cross-examined, have more experience cross-examination, or has just done a delay analysis on that type of project?
I mean, from my point of view, I think it very much depends where you are in the dispute. I think if you're on site and there's an issue rumbling, I think then it's a very good idea to get somebody who's got the practical experience that can give you a steer. I think also if you bring somebody in like that, they are more likely to have a bit of sway with your site team and your commercial team, because they will recognise that individual as somebody who sort of knows what they're talking about, rather than somebody who all they do is effectively professional expert reports, which, you know, they're often so far removed from actual, you know, working on site and knowing what is important and what isn't. But I think ultimately it's a question, it all depends. It depends on the dispute. It depends on a variety of things. I think from my point of view, it's more a case of what is a real red line. And for me, the red line is prior judicial criticism. You know, I think it's right that there are cases that are and actually should be career ending for the expert. And, you know, if they have been the subject of judicial criticism, that is a no. And you can often see in judgments where it's quite polite, but it's there. So that to me would be a red line. I think gravitas is good, but actually not gravitas in the sense of you don't need a sort of uber expert on a dispute that isn't worth very much. Why would you, you know, in the same way as you pick counsel, you don't need the great and the good in order to run a relatively modest claim. For me, recently, it's availability. Don't take the job if you're not available to service it. And it's not just a case of sort of looking at something and going, yeah, I can give a preliminary review now, and then I won't need to be bothered until trial or expert reports. It's, you know, I think it is now very much a team process. So you need your team for the pre-action stage. You certainly need your team for the pleading stage. And, you know, there will be issues that crop up throughout that you need your expert to be relatively available to consider new facts and give a steer. So, you know, if you previously, your view has been X, there's further information comes out and your view might alter, and it might properly alter, or it might be that it firms up or the like. That's the sort of involvement you need, so that you're not continuing with litigation and all of the cost racking up, when actually if you'd managed to speak to your expert would have said, right, okay, things have changed now, we need to look at settling this. So its availability for me is really key. And I would, time and time again, rather have perhaps a less well-known name and have them available and able to be part of a team, than, you know, you've got a big name and hopefully that'll scare the opposition, but you can't get hold of them.
Good. Thank you very much. Okay, so Annie, if you're listening and watching, and I'm not sure if you will be at this stage, but if you could pop the link to our YouTube channel into the chat, that would be very helpful. All of the recordings from past sessions, and hopefully this one, will be online on YouTube very shortly. If you go into YouTube and search for Limeslade, it will come up straight away, so do that. So very quickly, 2 final questions. Matt, if you could start with, what's the single most challenging or possibly annoying thing you've had to face when being appointed and instructed as an expert, and how can you avoid those difficulties or challenges? And particularly, I guess this is not necessarily, I guess it's, I think it's working with experts as instructing solicitors or counsel. What the things that can make things as smooth as possible, I guess, is the question, isn't it?
Well, I think for us, and I've also had this conversation with the team as well, is the sort of the clarity and timing of instruction, and that's followed by sort of general communication from the legal team. So we find that when we get an appointment, we tend to start the work, but the wording of the instruction doesn't get defined until much later on in the process. I mean, this is obviously because we're tasked to undertake generally a full opinion of the delay analysis and the issues. Obviously, the advantages of this is that we can simply progress, but at the risk that the instruction may change and require additional work. I mean, I can understand it from the lawyer's point of view that having specific wording too early on, can restrict the process and cause additional issues, and potentially is focusing too narrowly on certain aspects, which is an issue. Obviously, we're there to sort of support this sort of the tribunal, and also just general communication. I sometimes find that lawyers can be very good at getting hold of you when they need something, and then go very quiet when things aren't moving so quickly. So, for example, I'll take Jess's point before, that obviously having an expert available is great, and you prefer the availability. But then the upside is we can be available, but with the changes in timetables that occur, clients' positions, potential settlements, if we got communicated that a little bit earlier, then we could then rearrange other items around that change in timetable. So apologies for the slight rant, but it's really, communication is really key through the process for us.
I would second that rant. I mean, communication as to what is required and when, so nobody gets that sort of last minute phone call on a Friday evening and, we need an opinion by, yesterday. If everybody communicates, the whole thing works better. But I do think that it's time to have a bit more sort of consciousness of the fact that it's a team endeavour, usually from the outset.
Dan, have you got anything to add to that? Any other perspectives on how to make things smoother?
No, I'm just going to echo that same soapbox item in regards to the communication. I think that there's sometimes an issue with experts where you put a proposal in and then you don't really hear anything, and then suddenly you get the email turn around saying practitioner has been appointed, and you don't hear anything, and then it's going to report please in a week, which is fine, and that's never a problem, but it's regards to managing workload and diaries becomes quite difficult, and about other items you may want to take on or not take on without necessarily knowing the full timetable requirements or that communication level on the existing matters.
Good, thanks. And from the other perspective, I wonder if Jessica, the answer is the same. What's the most challenging perspective from your perspective? Sorry, the challenging thing, and how can how can working with experts be made easier? Is it the same answer?
It's pretty much the same point. The only other bugbear I really have is experts who form a view before they've read everything and before they've thought about something, and then having expressed that very preliminary view on the basis of no information whatsoever, then refuse to budge from it in quite a sort of obstinate way. That I find quite irritating. And I think the other point is experts whose opinions are a bit woolly, and it's like, yeah, you know, I'd say that for mediation, but, you know, I wouldn't put it in a report. That's sort of, I don't like that. I think I'd rather know exactly what their view is, but I think you don't start on that view, and you certainly don't go to the barricades to defend it unless and until you've read everything.
Good. Okay, thank you. Okay, there's one or two questions that have come through in the chat, and Jessica's very helpfully answered some of them already. We might actually have a discussion so that people, in case anyone else has a view, but just firstly, there's one in the actual chat that says, how does the panel feel about experts working for and against the same party? How long should the expert leave between cases? And can experts in different disciplines in the same business, and I think I know what this is, I'm sure we all know what this is alluding to, work for and against the same party on different disputes, provided the files on each dispute are kept concealed from the other expert? So this is obviously, if you work in a big firm, as I once did, you're quite familiar with the situations where there'll be an expert in one office and an expert at the other end of the country who may be working on a similar dispute or the same dispute on different matters, and the two are not allowed to speak to each other. I guess perhaps if we could start with Jess, as you're unmuted, what's your view on this? And I guess it's similar for counsel.
It's similar for counsel, but I don't think it's the same.
No.
We are, you know, we are independent, we're self-employed. Yes, we club together in chambers to sort of share expenses and the like, but we are not shareholders or employees, which are, and it's that point of distinction that I think that was Justice O'Farrell's decision in ABC XYZ, which sort of gives rise to, you know, fiduciary duties, which I must admit, I read it and I thought that was perhaps not the conclusion I expected. But I think there are differences between experts and counsel. And, you know, I mean, there's been no guidance at all on how long you leave it. I mean, you know, a fiduciary duty once owed doesn't sort of fall away. So it's difficult. I'm not sure that's, I mean, I guess for the huge multidiscipline expert firms, that's nigh on impossible to manage. And my understanding was it caused a huge flap in the expert witness industry. Undoubtedly, it will work its way through, and there will be, I think probably the answer is, ultimately clients are going to have to consent to what might otherwise be, you know, a breach of fiduciary duty, insofar as that can be consented. I mean, the other alternative is these huge mega firms are going to have to look at splitting, you know, either disciplines or something. Otherwise, this is a huge problem.
Matt and Dan, I don't want to put you on the spot, but neither of you work for a mega firm. So do you have any views on this? I don't want to, as I say, if you don't feel comfortable answering, please don't feel you have to. But
no, I think that decision made us look at our sort of conflicts a little bit in a bit more detail to make sure that we've got all the teams, especially bringing new members in who may be on live appointments. It made us be more aware of the situation and to manage it. I mean, I take Jess's point that obviously barristers are self-employed, but in some aspects, although experts are employed, they're the named expert on the job, so it can be difficult because they may be purely focused on that job. But it's obviously a decision that's come through. But.
Good. And Dan, you have unmuted, so I'm going to target you, seeing as you've taken that risk. What's your view?
I think for us, the key thing is, more so now than ever before, we've actually spent a lot more time discussing it with the instructing solicitors and the legal firms to actually make sure that anything we need to disclose has been disclosed. The question over how long do things need to be left, we've struggled to find guidance on these items recently. And for us, it's been very much a situation that if in doubt, disclose it and have the conversation at the start before the appointment and before you start doing work.
Good. Okay.
I must say, I was always surprised that case didn't go to appeal. Very surprised, given the repercussions it's obviously had. Who knows? Yeah.
Okay. So that's very helpful. We shall have one last question, I think, because I think I'll bring this question out because it's Jess has already answered it in the chat, but I'd be interested to see the experts' views as well, which is the one about prior to adjudication, should there be an expert determination to narrow the argument? Jess has responded, no, I don't think it ever helps to narrow the argument. In actual fact, it could have the reverse. Parties then find more arguments to escape the expert's conclusions. Matt and Dan, do you have any views beyond that?
I think my view is sadly the age-old easy get out of jail card, which is it depends. And having been appointed on a number of matters, well, not number, a couple of matters where the parties wanted to avoid adjudication. It was midway through a very large construction project. The parties wanted to actually have a means to get a quick resolution to very discrete items. It wasn't the kitchen sink type adjudication, it was discrete items. On that one, I was appointed as the expert determination, and I think it worked very effectively. Both parties had consented to the appointment, and it avoided adjudication, avoided slightly more formal dispute resolution procedures. Now, that was a situation where the timetable was very short. I think it was like 7 days to give an opinion. It was phrased as a recommendation rather than a full-blown determination, so the parties were free to continue to dispute it. But over the course of a couple of years, I think must have made it was definitely into double figures, but not very high kind of number of recommendations, and virtually all of them were accepted. And my understanding is the project avoided adjudication, which is where there were parties were threatening that at the start of it. So if the parties have the right attitude and it's the right situation, it can work. But by the same token, I've seen the fallout from other situations where it hasn't worked, and you just find yourself in an even bigger dispute.
Matt?
Yeah, I sort of agree with Dan. We've actually looked into the expert determination. We've got one of our guys going through a training process at the moment. And I think for the world of delay, I think it actually can be quite convenient. I don't think that the lawyers like it too much because they're not too involved in the process. But I think for this, that's a different. But it's not like adjudication. I mean, if you got an expert in delay to review it in a neutral position, you could probably get to a resolution quicker and more cost efficient. Like I say, if the parties are allowed to continue to dispute it after, then obviously the cost will then rise naturally. But you know, I think the principle and the idea of it is good. I think it goes back to sort of the original thoughts of what adjudication should be, to increase cash flow and get rid of disputes.
I'm just going to pop in here and defend the slur that we don't like things we're not involved in. That's not right at all. My quibble with something like that is making it a compulsory step in the dispute resolution process. I think if you've got parties that just want a quick answer, binding or non-binding, those parties are behaving sensibly and can no doubt make it work. It doesn't work in every situation. My preference would be, look, it's part of the list of, the options that are available to parties that are in dispute. Sensible parties can pick it up, but it should not be imposed on parties who are, determined to take their dispute further. If it's compulsory and there is there's no mutuality between their positions and their desire to resolve things early on, then it's not a helpful additional step.
I think I'd add to my point as well, is obviously that I wasn't suggesting we get rid of the legal representation, because actually from a delay analysis point of view, maybe technical or legal points come out of it, so you would need it. No, it's fine. I just, but because the technical legal points come out, which would potentially be out of a delay expert sort of remit, then obviously you would need the involvement and the legal point of who's responsible. So, you know, it has its good side and also has its negative points too.
Good. Okay. Right. Well, that's really helpful. Thank you very much indeed. I think we'll call it a day there because we've reached 44 minutes, so that's good. Annie will be pleased because I finished my bit by past. So thank you to all of our speakers this morning. Thanks to Matt, Jessica and to Dan. Thank you to everyone for joining us. As I say, do join us for UK Construction Week's session on the 14th of July. The link is in there in the chat, and we will, of course, be promoting it through email and LinkedIn and all the usual places. And enjoy the rest of your day. Thank you very much indeed for joining us. Cheers.
Thank you very much. See you. Bye-bye.
Thank you. Bye.